All the latest in litigation against Illinois' gun and magazine ban. A couple of different things happening that we're going to delve into here with Bishop on Air. Be sure to like, subscribe, follow along, hit that notification bell on YouTube, follow me on X, follow me on Facebook, and stay up to date with what's going on. Last week, we had an update from attorney Thomas DeVore about his cases challenging the state's gun and magazine ban. And the background on that, of course, is that you had the cases vacated by the judge after the Illinois Supreme Court in a separate case brought by State Representative Dan Calkins going for the state. But attorney Thomas DeVore attempted to get those reinstated with his cases. And to get the latest there and what the next steps are, he joins us now here with Bishop on Air. Tom, thanks for taking time with us, and let's get right on into it. What is the latest when it comes to your cases?
Well, the latest is, again, with being as respectful to the court as I can be, it was no surprise to me that the judge was not going to grant our request to reconsider, and I'll leave it at that. But there's zero chance, Greg, that this case doesn't come back from the appellate court. And lawyers never say zero, but under these circumstances, I'll tell you it's zero. You know, all the Illinois Supreme Court said in the Calkins case is, and when you said it was a related case, it wasn't related, it was identical, at least as it was filed, said that you can't just have what's called a facial challenge to this law, which means that you just can't, as a general proposition, say it's not constitutional. You have to get into the nuts and bolts and the facts, which is what we were trying to do. So we're going to go to we've already filed our notice of appeal. I had it ready already because I knew what the judge was going to do, again, with all due respect. And it's going to come back, and it's going to be back in front of the court arguing the issues that I've always been intending to argue since day one when I filed this case, which is that these exempt categories are but a facade, and I can get the facts to actually prove that. And beyond that too, Greg, I mean, all I have to do is just refile a brand new case again and start the process all over. So, I mean, the judge just kicked the can down the road. He didn't stop this case. And the Illinois Supreme Court, in their ruling in Calkins, did one good thing, is they gave me a roadmap on exactly how I can win the arguments on equal protection.
So talk a bit, if you can, about your confidence here that the appellate courts will see it your way, that these cases Absolutely. Should be reinstated.
Well, yeah, it's because all of the Illinois Supreme Court said is that if you come to us saying this law is on its face unconstitutional merely because of the words in the law, you can't win that case. And they made that clear. And so we explained to the judge, we're not talking about what's called a facial challenge. We're talking about an as-applied challenge where we're going to get into the facts. I mean, you've been with me on this case, Greg, since day one. Get into the facts, and we can prove to you why retired police officers are not different than law-abiding gun-owning citizens, and why security officers are not different, you know. And we're actually getting into that. Calkins never got into any of that stuff, which is why he lost. And we explained to the judge, we have a right, our clients have a right to explore those facts and to make that case. And that's what distinguishes our case from Calkins. And the judge didn't even, in his ruling, he didn't even explain himself. He merely said Calkins is controlling. And it's not controlling, and there's zero chance that Calkins controls our case. And so it will come back from the appellate court. But in the meantime, I think it's important to know it doesn't stop us from filing another case. And we got actually two cases that we're going to file in the state court right now against this gun ban. And they'll be coming in one of them will be next week, and the other one will be a couple weeks after.
Talk more, if you can, about the training component here. We've delved into that before, but I mean, you've gotten documents about training, and this seems to be something that at least was brought up after the law was passed as to why there's these exempt classes, so to speak. But I remember listening to the debate, and there really wasn't much at all debated or talked about when the law was being crafted and ultimately passed, that these individuals have this specified training.
It's because, Greg, and I'm not going to say people's names because I wouldn't do that to my colleagues, but I can tell you with 100% certainty, because I've had the conversations, that they made that up after I filed the lawsuit in the state court, because they fully expected, when I say they, I'm talking about the governor, the attorney general, the legislatures, they fully expected a Second Amendment litigation effort in the federal court, and that's what they were preparing for. They never saw coming an equal protection claim in a state court. It just completely caught them off guard. And so they made this training argument up on the fly because they had to come up with something. But set that aside. What the Illinois Supreme Court has said, and I believe eventually that the U.S. Supreme Court will strike it down, but that's for a different conversation. The law in Illinois right now is, at least on its face, if a particular exempt category has two things, Greg, and it's conjunctive and it both must be present. You have a duty to protect the public order. A duty. That means under the law, you have a duty as a holder of a particular public office to protect the public order. Let's give that to currently active law enforcement. That's fine. And you have training on top of that with firearms. If you are that, then you are not similar to just a FOID card carrying gun owner. That's all that the Calkins case stood for, is that if you have trainings, we'll get to the type of training in a second, and if you have a duty under the law to protect the public order, you can be exempt from the requirements of this law. But here's where the rubber meets the road, and here's where our case is different, the one that's pending and going to the appellate court, or a brand new case I'll file, which I can do anytime I want, is these categories, Greg, these 7 exempt categories. If you break them down, you will find that almost none of them have a duty to protect the public order and the training. Let me talk about the training first. The Illinois Supreme Court left unaddressed, because Calkins was foolish, what type of training are we even talking about? Does it have to be training on the banned weapons? Intelligent people would say yes. The Attorney General's office actually argued in our case that these exempt categories were trained in the banned weapons, but the Illinois Supreme Court didn't touch upon that. It was just left out of what type of training. Set that aside. Let's talk about duty. You have a duty to protect the public order. Because if you're in those exempt categories and you don't have a duty to protect the public order, then you can't be exempt. The Illinois Supreme Court never touched upon that because Calkins didn't do what I was always intending to do, which is to pick apart these categories and show how they don't have anything extraordinary. Let me give you an example. Retired law enforcement officers is an exempt category under this law. Retired law enforcement officers, Greg, have no duty to protect the public. Zero. There's case law that's scattered throughout our appellate courts and our Supreme Court that says a retired law enforcement officer is just like an ordinary citizen. He has no duty. But yet this law exempts them, and under the Calkins standard, if I accept the Calkins standard on its face, retired law enforcement officers can't be exempt. It's unconstitutional because they have no duty. Who else has no duty? Security officers. They don't have a duty to protect the public. There's case law that says they're like an ordinary citizen. So when you start chipping away in the facts of these exempt categories and you apply the Calkins standard and just say, okay, I'll accept that law, almost all of these categories fall away because they lack duty. And again, we still have to address what type of training they should have, because almost none of them have any training on the banned weapons. It's mostly handguns. That's what's going to happen in this case. And so I will use the Calkins standard to tear this law apart. And I think the governor and the attorney generals know it, which is why they're trying so hard to keep us out of the court, but they won't.
So we'll be watching this as it moves forward. Tom DeVore, of course, last week, an Effingham County judge denying reinstating those cases, you taking it to the appellate court, and obviously, as you said, you could file a separate case altogether and start back at the district court, so we'll be watching that. Yeah, and if you could, I mean, react to some of what the governor's had to say about low registration rates. I mean, last week he said that these weapons are too expensive, some pointing out that a billionaire talking about things being too expensive is kind of ironic, but your thoughts on the governor, just his reaction to the what all accounts are just abysmal registration rates for this law.
Well, I think what the governor is experiencing, and I personally believe it's healthy, even though I never advise anybody to break the law, is that when you start, and this would be the same response I would give you, Greg, if you had a bunch of ultra-right conservatives pushing conservative ideologies on the far end of that spectrum and how those who maybe lean left or more liberal would respond to, is that you have to govern in the middle. And the governor doesn't care about that whatsoever. You have to govern in the middle. And when he passed this ultra liberal policy, people just overwhelmingly said, okay, that's fine. We're not going to listen to you, because people are always in control, whether they know it or not. And there's nothing that the governor can do about it. He, under no set of facts, has any ability to force what is probably right now millions of gun owners to do something they don't want to do. I mean, and so ultimately what I think he's witnessing and experiencing and we're seeing in our state is when enough people, regardless of their political ideology, say no, there's nothing government can do about it whatsoever. And you saw some of what was written, and I know it to be true. The governor wants this gun registry because he has a desire to issue an executive order if, and sadly when we may have another mass casualty. He's thinking he can issue an executive order forcing these people to turn these guns over. It's always been a desire of people like Governor Pritzker, they just can't say it out loud, to take these types of weapons away from people. That's always been their agenda. That's always what they want to accomplish. They just won't say it out loud because it's too risque. But this is just a path for him to try to do that. And they're mad because the registry is not being used the way they wanted it to. And at the end of the day, I kind of think it's funny.
Well, even when I asked the governor last month, why have a registry, he said it's, to keep these very, very dangerous weapons out of individuals' hands and to know where they are if and when there's another crime committed with these weapons. He didn't go to that next step and indicate that he was going to issue an executive order. But, he wants to know where these firearms are if and when there's another crime committed with them.
We'll do this, Greg, and I talked to a lady from News Channel 20 a week or two ago, and I said this. I'm like, look, they're going to deflect every possible way they can. I said, but ask this question, if you're interested, to the governor's office. Do you believe that you have the authority to issue an executive order requiring the return of these weapons from people that have registered if there's some type of mass casualty? Do you think you have the power to do that? Yes or no? He won't answer the question. I guarantee you he won't answer the question, because if he would say no, he'd put himself in a box. If he says yes, then everybody knows what he's really been trying to accomplish all along. Ask that question, Greg, when you get a chance. Very specifically, yes or no, do you have that power? You won't get an answer, I promise you, which should tell you everything you need to know.
Attorney Thomas DeVore, greatly appreciate you taking the time with us this morning. We'll definitely connect in the near future and get an update on where we're at with your cases. All right? So be safe out there.
All right. Take care, Greg.
It is Bishop on Air, and appreciate Attorney DeVore taking the time with us this morning and giving us a breakdown of where he's at with his cases and exactly how we're going to proceed forward. So appreciate that, and we'll continue to track that case and more. It is Bishop on Air. Like, subscribe, hit that notification bell. If you watched live this morning, the video is really poor quality live, but we are capturing this locally, so the video uploaded should be just fine. So be sure to check back, hit that notification bell on YouTube, and be sure to like and subscribe, all right? Stay tuned. More coming up.